Right out of the gate, this case hits hard. A father walks into court saying he's been paying child support for 5 years while his kids barely spend any nights with their mother. He's asking for something simple: make the paperwork match reality. Full physical custody, no more support payments, and recognition that he's been the primary parent all along. But as we're about to see, family court isn't just about what feels fair, it's about legal definitions, overnight calculations, and formal filings. Stay with us, because what starts as a straightforward request quickly turns into a lesson on custody law, support retroactivity, and why waiting too long to file can cost you thousands. And here's the big question: if your kids live with you almost full time, should you still be paying child support?
And she's going to make this difficult. I've been paying child support for 5 years, and the kids just don't go over there at all.
I spend as much time as I can with my children. It's not, I know the overnights is, maybe that's what the court views it as. He bought her a dog.
Dad wants his overnights changed so he can stop paying child support, and so Mom can begin paying him child support.
All right, sir, and these are your motions, is that correct? Or your motion regarding parenting time, support, and custody, is that correct?
Yes, sir.
All right, and what are you looking to change?
Just what has happened for the last 5 years. The kids haven't been going to their moms at all. I've been paying child support the entire time. Should have probably done this a long time ago, but yeah, no, it's been, maybe 5-6 times a year for the last 4 or 5 years. They've been to their mom's house, and so I just want what's already going on: full parenting time, no child support, full custody. It is what has happened.
All right, how many children under 18 do you have right now?
Just one now. My son is just turned 18.
Is your son still in high school or not?
No.
Okay. All right, so obviously we won't do anything related to him. Then you have another child that is how old?
16.
And it's your indication that you have the full custody at this time?
Yes, I have had for years.
And what type of parenting time is she spending with mom?
I don't know, 4 or 5 times, maybe, I don't know, up to 10 times a year, possibly 10 nights a year.
This is a crucial moment. The father explains that the kids stay with their mom maybe 5 to 10 nights per year, and even those nights often happen only when he needs help with early mornings for work. From a legal standpoint, that matters. In family court, overnights are one of the biggest factors in calculating child support. It's not about who buys clothes or cooks dinner, it's about where the child sleeps. That's why he's pushing for primary physical custody on paper. Without that change, the system still treats this as shared custody, even if real life tells a totally different story. Let me ask you, if you were paying support but doing nearly all the parenting, would you have waited 5 years to file like this?
But that would be on the very high end.
All right, is that a set schedule, or how does that come about when she goes to mom's house?
Just when it's absolutely necessary. There are times when I have to be at work very early in the morning, and we'll ask Nicole to drive them to school, and she will agree but demand that they stay the night if for her to do so, so they begrudgingly stay the night. There have been a couple times where she just wanted to stay with her mom, but it's just been a couple times.
Are you seeking to change so obviously you're looking for the primary physical custody. What about legal custody? Are you asking if that be changed to legal custody or continue jointly?
I was asking for everything to be changed only because I was having difficulty getting advice. My main goal is to just not pay child support anymore, because all the money is going to my ex-wife and none of it's going to the kids. Plus I'm paying to support the children every day, all day, so I'm paying.
Let's get back to, are you asking to change the legal custody or keep the legal custody joint?
I guess change it only because of my ignorance, and I don't know exactly how that affects anything. I'll let them see their mom whenever they want to. I've always done that. But
legal custody has no impact on what your child support is. Legal custody just refers that the parties should work together to make major decisions, things like school or medical issues.
Yeah, no, that's legal custody. It's fine if I'm not asking asking the court to take legal custody.
Here's where the judge steps in to clarify something many people misunderstand: legal custody versus physical custody. Legal custody is about decision-making, school, medical care, major life choices. Physical custody is about where the child actually lives, and only physical custody affects child support. The father admits he doesn't fully understand the difference, but makes it clear he's not trying to block the mother from seeing the kids. His main concern is financial fairness. He says he's supporting the children daily while the support money goes straight to his ex. This is a textbook example of why knowing your rights early matters. A simple misunderstanding of custody terms can keep someone paying for years longer than necessary.
Be away from her, no.
All right, thank you. All right, Ms. Jones, what are your response? Essentially, he's seeking that the physical custody be changed to indicate that he has the primary physical custody, and that you essentially have parenting time as agreed. And he indicates it's about 10 overnights a year. What are your thoughts on that?
I spend as much time as I can with my children. It's not, I know the overnights is, maybe that's what the court views it as. He bought her a dog and she's been required to be there to take care of the dog. So that's a lot of the time where I live. She asked me to get a dog and I said no, because we're not home enough. Plus where I do.
I'm gonna redirect you to kind of what I was asking you. So he's asking it to be changed to indicate that parenting time is as.
Now we finally hear from the mother, and her explanation centers around a dog and informal visits, not actual overnights. That's important. Courts don't calculate child support based on errands, favors, or daytime visits. They look at structured parenting time. She asks for percentages and schedules, and the judge explains that since their current order already says, as agreed, either parent can request a formal schedule. This moment highlights the real issue. There is no set plan. When parenting time is vague, disputes like this are almost inevitable. So let me ask you, should courts require detailed schedules from the start to avoid situations like this?
Agreed. Are you in agreement with that or not in agreement with that? And that he has the primary physical?
Is there like a set percentage of time that we can say that I can have my daughter versus him saying whenever she wants, or can we, how do we do that?
Absolutely. You guys can have a hearing and we'll determine that. I think your last order just indicated again that it was parenting time is as the parties agree. So there is no set specific schedule. A parent is always entitled to seek a specific parenting time schedule. Is that what you would like to do, ma'am?
Well, I spoke to their daughter and she said she wanted to keep it the same. She wants to be able to do what she wants. So I told her we might have to change that, but depending on what Mr. Jones wants to do.
Well, what he wants to do appears is that the order indicate that he has the primary physical and that parenting time is as the parties agreed. Is that correct, Mr. Jones?
Yes, Your Honor. I will always let Nicole have the kids whenever she or they want. I've never stood in their way ever. I think one time I didn't let her go on vacation.
All right, that's okay, sir. We don't need to get into that. So just trying to see if we reach an agreement. If we don't have an agreement, we'll just set the matter for a court hearing. So, Ms. Jones, the proposal is that the language simply be changed. You currently already have parenting time as you agree, is what the order says, but you have joint physical. Mr. Jones is requesting that he have the primary physical, and then that we change whatever the overnights is as far as calculating support. So do you agree?
Support is my.
Ms. Jones, do you agree to a change that gives Mr. Jones primary physical custody?
And there it is, no agreement. That means this case moves from discussion to litigation. The judge schedules a full in-person hearing and orders their 16-year-old daughter to appear for a child preference interview. That's a serious step. At this age, the court will consider the child's wishes when determining custody. This changes everything. It's no longer just mom versus dad. Now the daughter's voice becomes part of the legal record. That upcoming April hearing will decide who truly has primary physical custody and how support is calculated going forward.
No.
Okay, we will set the matter then for a court hearing. We can set it for April 17th. That would be at 11 a.m. That is a in-person court hearing. And given your daughter's age, she needs to appear also, so I can do the required child preference interview.
Thank you, Your Honor.
You're welcome. Any questions, Mr. Jones?
I guess just as my other, I filled out quite a bit of paperwork. This is just barely touching on it. There were arrearages that were ordered during a time when I was already ordered to pay all the household bills, but he had it arrearages on top of that. I would like that to be addressed. I would like to be addressed the fact that I've been paying child support. Since she's going to make this difficult, I've been paying child support for 5 years, and the kids just don't go over there at all. For
All right,
all
sir.
intents
Well,
and purposes.
we will,
And
as part of that hearing, I will address support, but I will tell you that we can only modify support back to the date that your motion was filed. We can't go back further than that because you did not file a motion to do so. So we can't go back in time that far back. We can only go to the date.
This might be the most painful reality check of the entire hearing. The judge explains that even if the father proves he should have had custody years ago, the court can only modify child support back to the filing date, February 12th, not 5 years, not even 1 year, just the day he officially filed. That's the law. Family court doesn't work on hindsight, it works on paperwork. This means any support change can only be retroactive to that single date. A powerful reminder, if your situation changes, file immediately. Waiting can cost you tens of thousands.
Date that you actually filed your motion, okay?
so I'm going to continue
So
to pay
any-
child support until that date. Is that the case? I mean, my big problem here is
Currently, there is an
I had a-
active support order, and we can make your support retroactive. If you are successful in a support change or any support change that is made, it would be retroactive back to the date you filed your motion, which was February 12th. All right, that's the law of the matter. So we will see you both here in person, as well as your daughter on April 17th at 11 a.m.
So let's wrap this up. A father seeking fairness after years of paying child support while raising his child full-time now faces a formal custody hearing, a child preference interview, and a legal system that can't undo the past, only move forward from the filing date. The judge made it clear, physical custody determines support, legal custody does not, and retroactive changes have strict limits. This case shows how quickly informal parenting arrangements can turn into financial traps when they're not reflected in court orders. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns on the Legal Watch.